Welcome back to FDVN's channel. In today's video, we will introduce a new vocabulary lesson on the topic of money laundering procedure. The main content today we will learn together about obligations for people performing related business, through the section, Part 1. Listening and fill in the blanks, Part 2. Learn vocabulary. Now, let's get started. Systems and Training etc.to prevent money laundering. 1. Every person must in the course of relevant business carried on by him in the United Kingdom, a. Comply with the requirements of regulations 4, identification procedures, 6, record-keeping procedures, and 7, internal reporting procedures, b. Establish such other procedures of internal control and communication as may be appropriate for the purposes of forestalling and preventing money laundering and c. Take appropriate measures so that relevant employees are made aware of the provisions of these regulations, Part 7 of the Proceeds of Crime Act 2002, Money Laundering, and Section 18 and 21A of the Terrorism Act 2000. 2. Given training in how to recognize and deal with transactions which may be related to money laundering. 2. A person who contravenes this regulation is guilty of an offense and liable, a. on conviction on indictment to imprisonment for a term not exceeding 2 years to a fine or to both, b. on summary conviction to a fine not exceeding the statutory minimum. 3. In proceeding against any person for an offense under this regulation, it is a defense for that person to show that he took all reasonable steps and exercised all due diligence to avoid committing the offense. Identification procedures. 1. In this regulation and in regulations 5 to 7-a, means a person who carries on relevant business in the United Kingdom, and b. means an applicant for business. 2. This regulation applies if -a and b form, or agree to form a business relationship, b. in respect of any one-off transaction, a knows or suspects that the transaction involves money laundering, or 2. Payment of €15,000 or more is to be made by or to be, or c. in respect of 2 or more one-off transactions, it appears to a. whether at the outset or subsequently, that the transactions are linked and involve, in total, the payment of €15,000 or more by or to be. 3. A must maintain identification procedures which -a require that as soon as is reasonably practicable after contact is first made between A and B must produce satisfactory evidence of his identity, or 2. Such measures specified in the procedures must be taken in order to produce satisfactory evidence of B's identity. b. Take into account the greater potential for money laundering which arises when B is not physically present when being identified. c. Require that where satisfactory evidence of identity is not obtained, the business relationship or one-off transaction must not proceed any further, and d. Require that where B acts or appears to act for another person, reasonable measures must be taken for the purpose of establishing the identity of that person. Regulation 7, Internal Reporting Procedure. 1. A must maintain internal reporting procedures which require that a person in A's organization is nominated to exit disclosures under this regulation, the nominated officer. Complete the definitions. Look at A opposite to help you. 1. Money laundering, process by which finance obtained through crime is used in such a way that it appears to originate from a legitimate source. 2. One-off transaction, a business activity not carried out in the course of an existing business relationship. 3. Forestalling, anticipating and hindering. 4. As soon as is reasonably practicable, as quickly as possible. 5. Exercised all due diligence, took every care and carried out required procedures. 6. Disclosures, confidential information made public. 2. Replace the underlined words and phrases in the memo below with alternative words and phrases from A opposite. Pay attention to grammatical context. Bridgman Banks, Internal Memorandum. Date, April 23, 2007. To all partners and fee earners. From Peter O'Donnell. Subject, Money Laundering Procedures.
You will no doubt be aware of the serious implications for legal firms and their employees of failing to 1. Observe the 2. Profits from Crime Act and the money laundering regulations. Given that it is possible to become unintentionally involved in a money laundering transaction in the course of, for example, a property purchase, or in a situation where you 3. Carry out activities on behalf of someone else, the firm is anxious to put in place systems and to provide training to ensure that there are effective procedures so that employees do not risk 4. Breaking the regulation. The penalties following criminal prosecution and conviction may comprise imprisonment and a 5. Money penalty. We need to be able to demonstrate that we 6. Did what was possible and 7. Carried out all formal requirements to avoid committing an offense. The main offenses under the current legislation are not 8. Hindering or preventing a money laundering arrangement. Not making a 9. Statement if you know or 10. Guess money laundering. Prejudicing an investigation, for example by tipping off a suspect. Evidence of identity. As you know, the precedent form of the client care letter for new clients and the firm's standard terms of business contain information to make clients 11. Conscious of our obligations under the legislation. An important part of our procedures is the requirement to produce 12. Sufficient proof of identity from new clients as soon as is reasonably practicable. Obviously there are different requirements, for example, appearance in person, passport, driving license, etc., for different types of client, and the relevant guidance is set out in the office manual. What to do if you are suspicious. Internal reporting procedures. I am the firm's 13. Named money laundering reporting officer. If you have any suspicions at all, either about a particular client or any aspect of a 14. Business activity, please feel free to contact me. If I think we need to refer the matter to the National Criminal Intelligence Service, it is extremely unlikely we will be able to inform the client. This can amount to tipping off. If NCIS decides to investigate, we will have to terminate our retainer with the client.